Welcome, everyone, to the first session of National Interstate and Vanliner Insurance's 2026 webinar series. Throughout the year, you are invited to attend our live webinars focused on providing education to motor carriers on compliance updates, technology adoption, claims management best practices, and emerging safety trends in the commercial transportation industry. Our content today will be delivered by Brandon Wiseman, the founder of Trucksafe Consulting. Brandon is a transportation attorney, safety consultant, and the founder of Trucksafe. Over the years, Brandon has had the privilege of representing some of the nation's leading motor carriers and transportation providers on matters relating to USDOT safety and compliance. Trucksafe is a full-service DOT regulatory compliance, consulting, and training service. They help carriers develop, implement, and improve their safety programs through personalized service and industry-leading training resources. Today's webinar is going to be focused on Federal Motor Carrier Safety Administration regulatory updates that went into effect in 2025 and what we should be looking out for in 2026. I'm Chris Steinbauer. I'll be your moderator for today's session. As we go through the presentation today, feel free to drop any questions in the chat. We'll try to get to as many as we can throughout the presentation today. Also, please stick around until the very end for a special offer from National Interstate, Vanliner, and Trucksafe. With that being said, I'm excited to introduce Brandon from Trucksafe Consulting.
All right. Thanks, Chris. And thanks to National Interstate Vanliner for having me. Always love working with those guys. And welcome to everyone who is here with us. Thanks for being here. It's the first time I've ever really had a hype video starting out my presentation, so that was nice. I'm going to have to add that to all of my future appearances here. But in any event, how are we all feeling about the current state of DOT safety and compliance? Are we feeling good about it? Because I got to be a little honest. It's a little disheartening to turn on the news, the national news, every day and see something about trucking. And by something, I mean usually some kind of catastrophic crash or some new investigation about chameleon carriers or English language proficiency or non-domiciled CDLs. And so, it's important that we kind of take stock of where we're at with DOT safety regulations and enforcement, because the reality is the target on your all's back has never been bigger than it is right now, obviously. And so, like I said, taking stock of where we are at currently and what's to come is important. So that's what we're going to do today. We're going to take a look back at some of the most significant enforcement initiatives by FMCSA that we saw last year, and then bleeding into this year, we'll take a look at some of the numbers that the DOT publishes in terms of the most common violations discovered in roadside inspections and also audits, and then we'll also dig deeper into what's to come for 2026, what you all should be looking out for from a rulemaking perspective, and also continued enforcement on some of these hot button issues like the ones I mentioned. So that's what we're going to do. Like I said, if you've got any questions, throw them in the chat or the Q&A. We'll take them as we go. Let's do this. See if I can move the slides here. We practiced this, I swear, and it worked earlier. For some reason, Chris, it's not working now, so you may need to do this for me. All right, so here's the agenda. Like I said, first we're going to take a look back at 2025. I like to do this at the start of every new year, just looking back at what were some of the most common violations discovered in those two contexts. It's a good level set to figure out what were the biggest issues that the DOT focused on last year or that were causing fleets the biggest trouble. So we'll do that before we turn to looking at 2026 and what's to come, and also an update on the current status of things. Somebody's saying they can only see blank slides, so I don't know if that's an issue on our end or their end. But let's move to the next slide. All right, so looking first then at DOT enforcement data from 2025. This is all publicly available. And I recommend, if you haven't checked it out, FMCSA has a part of their website called A&I. You just Google FMCSA A&I, you'll find it, and you will be able to see all of their inspection data for many years, and you could filter it, you could sort it by type of investigation, whether it be roadside or audits. You can also look at particular years. You can look at top violations. It's a wealth of information, and I find it's pretty useful for fleets to get a picture of where the DOT is spending most of their time, what issues are they spending most of their time looking at. And so that's what we're looking at here. I just pulled this down from FMCSA's A&I website, looking at 2025 roadside inspections. What are the top violations that are being written up as your drivers and your vehicles are getting stopped for roadside inspections? We'll start with the most common driver-related violations. And here they are. This is the list of the top 10 or so. And you can see on this list, these are all, I think all of them, all of them are driver behavior type violations. From year to year, these lists don't change all that much, although this was the first year that I've run this, I've been doing this for almost 20 years at this point. This is the first year I've run this top driver violation list, and I didn't see any hours of service in the top 10 hours of service related violations. It has been consumed by driver behavior type violations, traffic type violations, speeding, lane restrictions, seatbelt use, all of that type of stuff, lane change type stuff. Those are the most common violations that are getting written up roadside. Now, shortly down on this list, if you were to continue to expand it, you will see some of the usual suspects that we typically find on these lists, which are things like log falsifications, CDL violations. So don't get the misimpression that those are not issues for us any longer. They're still on the list. They're just they've been outpaced by some of these traffic related violations. So those are some of the top roadside violations we're seeing when it comes to the driver side of things. And what can we do to get control of these things so that these aren't as big of an issue for us in 2026? I mean, what can we say for these types of traffic type violations? What can you do to get control of speeding? Well, if you're a driver, you got to quit speeding, obviously. But if you are a fleet that is struggling with speeding violations, many struggle with that, and it's impacting your unsafe driving basic, you got to get control of it through the typical things that the tools that exist to you as a safety team to get control of them. I mean, there's no getting around it. You got to have an effective progressive disciplinary policy in place. You can't afford to have repeat offenders with these types of things. So you got to take these violations seriously, and you got to have effective controls in place to deal with them as they come up, so that they don't balloon into systemic issues and then really jack up your CSA scores. And next thing you know, you're ending up on lists like this that you don't want to be on. So we can move to the next slide here. Chris, you still awake there? There we go. Okay, so that was looking at the driver side of things. How about the vehicle side of things? What are the top violations that we saw written up 2025 that are vehicle related? And here they are. Number one, far and away, most common vehicle related violation written roadside: operating a commercial motor vehicle without proof of an annual DOT inspection. Believe it or not, that is at the top of the list, significantly outpacing the other top vehicle related violations on this list. This is such an easy fix that I don't know why we are continuing to incur so many of these violations. It's literally just having proof that vehicle, either whether it be the truck or the trailer, has passed a DOT annual inspection. So I don't know what the root cause of this is. Hopefully it's not the case that many of these vehicles that were written up here didn't have an annual inspection. It's probably more likely the case that either they didn't have the sticker for it on the side of the truck, or they didn't have a copy of the report in the cab, or maybe just the sticker was worn off or something like that. I'm hoping it's more of a record keeping type deal than these vehicles actually not being periodically inspected as the regulations require. But it is what it is. It's an easy fix. Fleets have to ensure that all of their regulated equipment, trucks and trailers, and buses, if you're a bus company, are annually inspected at least every 12 months, and that you've got proof of it on the vehicle itself, whether in the form of the copy of the current annual inspection report or those stickers on the side. So make sure you got those, and then we shouldn't be having that issue there at the top of the list. Moving down from there are the usual suspects for vehicle violations, the things that continue to plague our industry and end up with just an abysmal vehicle out of service rate, national average, which consistently hovers around 25%. Nearly a quarter of all commercial vehicles operating out on the roadways have some kind of an out of service condition, which is just scary to think as we're out there driving around these trucks that, 1 in 4, 1 in 5 of them have some kind of a serious defect that would end up with it on the side of the road. But that's where we're at. And it's usually these things. It's the brakes, lights, and tires, BLTs. They are the common suspects. They continue to be significant problems for fleets. And so what's the solution to these? Well, a couple different things. Usually, in my experience working with fleets, regardless of their size, most of them struggle with drivers and their pre-trip inspections. Drivers just not doing thorough enough pre-trip inspections. Many of these things should have been caught before the vehicle ever left the yard, and they weren't caught. And and I get it. We're trying to keep the wheels moving here. Drivers want to get to work. They want to make money, and so they just pencil whip their pre-trip inspections, and we end up with all of these brakes, lights, and tires violations, which continue to compound on top of one another, and then we end up here. So pre-trip inspections, holding drivers accountable to doing thorough enough pre-trip inspections, and then, auditing those. If you're a fleet safety manager, going out and double checking yourself every so often. Driver does a pre-trip inspection, and you go do a walk around and see if you found any of the same things or anything like that. Again, really no substitute to that type of process, those types of controls. Having the policies in place to require the pre-trip inspections, and then holding drivers accountable through whatever mechanisms you use, progressive discipline, that type of stuff, is really the name of the game here. Moving down the list here, there's some other ones. Fire extinguishers, unsecured, very easy things to correct, but just so common to see roadside. We can move on to the next slide. All right. Okay, so those were roadside inspections. That's what we were seeing the DOT focus on, the DOT and its state law enforcement partners focus on from a roadside inspection perspective. But what about the other side of things? What about DOT audits, also known as compliance reviews? This is another area where you as a fleet can get yourself sideways. If you happen to get the knock at the door for an audit, which you never want to receive, what are we seeing in terms of the FMCSA's aggressiveness in pursuing compliance reviews, and also what types of violations are leading to trouble in that context? That's what we're looking at here. This is additional data that's available in the FMCSA's A&I system if you're ever interested in perusing that. So here's looking at 2025 compliance review data. Actually, this is looking at 2022 through currently. So again, the system, the A&I system, you can go in and filter by date, and you can look back several years. And so what we're looking at here, you could see total numbers of federal inspections, state inspections, and then total inspections. Even though those say state inspections, these are audits conducted by state enforcement agencies on behalf of FMCSA. And so these are compliance reviews that can result in a safety rating. So you can see here in the total investigations row here, in 2025, we saw a total of 11,195 compliance reviews by FMCSA of motor carriers, which was around the same number that we've seen for the last several years, slightly less than the last couple of years. And so far in 2026, we've only had 601 total investigations, at least those that have been logged into the system. And so, I mean, if nothing else, this kind of tells you something about the current state of the staffing issue that FMCSA has perennially. You may or may not know the FMCSA as an agency has at any given time around 1,000 employees. That number is actually down significantly currently. I think they're around 800 or so employees. And those 800 or so employees are charged with regulating nearly 800,000 truck and bus companies operating in the U.S. And given that disparity in those numbers, we just don't have, FMCSA just does not have the manpower to conduct any substantial number of these types of compliance reviews on any given year. So that's why you see only around 12,000 compliance reviews conducted throughout the course of a year. And that hamstrings the agency a little bit to do their job, which is to enforce these rules. But it is what it is, and it's going to be like that until we either get FMCSA some more resources or they end up changing the way that motor carrier compliance is assessed. Possibly, and we'll talk about this later, but possibly moving away from the need for an on-site audit to end up with a safety rating, and maybe moving more to kind of an on-demand scoring using your CSA scores or something like that. So that's kind of a just wait and see type deal, but those are what the numbers are showing us right now. Let's move to the next slide. So here are the top violations discovered in that context from last year, 2025. FMCSA comes in, sniffing around your records in your office. What are the most common violations they're discovering in that context? Well, this chart actually changes quite a bit from year to year. Maybe not from year to year, but every couple of years you'll start to see new things start to creep up towards the top of the list, and that's what we're seeing now. For many years, false logs was always at the top of the list. But more recently, you could see here that we are dealing now with more and more clearinghouse violations, which is particularly frustrating to me because now, the Drug and Alcohol Clearinghouse for CDL drivers has been in place for over 5 years. And I just know anecdotally from working with my own clients that so many fleets in the United States still do not know that the clearinghouse exists and they are not using it. And that boggles my mind. And the data is bearing that out here. Clearinghouse violations are at the top of the list when it comes to issues discovered in an audit. And those are leading to pretty substantial fines being issued to fleets, at least in my experience. DOT has the authority to issue $13,000 violation per clearinghouse violation if they wanted to. Now they use a methodology to determine the actual amount, so they never end up issuing the full amount per violation. But if they wanted to, they could theoretically impose a $13,000 fine per missed query or anything like that. So it's a big issue that fleets need to get a hold of. First of all, if you're a fleet that doesn't know what the clearinghouse is and you have CDL drivers, you better get up to speed pretty quickly because it's going to cause significant trouble for you, not only in the compliance review context, but also roadside inspections. If your drivers are not enrolled in the clearinghouse, that can show up in a roadside inspection. Beyond the clearinghouse, those are the top. Let's see, that's the top violation, and then the third one in between those is the false logs. This, like I said, has long been the most common violation discovered in a compliance review, and it is the number one driver of downgraded safety ratings in that context. So you want to know the number one reason that fleets get shut down in an audit or that fleets end up with a conditional safety rating, you're looking at it right there, number 2 on the list, log falsifications. And we can drill down even deeper into that. I could tell you that the number one driver of downgraded safety ratings and conditional ratings is misuse of personal conveyance status. The data bears that out. It is continuing to be a scourge on our industry, fleets and drivers, and I won't even put the blame on you all because the FMCSA has created this problem by not clearly defining personal conveyance and not clearly addressing it in its regulations. So that's partly on them, but partly on drivers and fleets for not understanding, not doing the work, the due diligence to understand what the guidance says about personal conveyance and what is a legitimate use and what is an illegitimate use of personal conveyance. I mean, just go talk to drivers and you'll hear them talking about, well, I ran out of hours, but I could get to this a safe haven under personal conveyance. Very common thing you'll hear. But that's wrong. I mean, it's completely wrong. If you run out of hours while you're on the road, there is no such thing as a safe haven allowance that allows your drivers to flip into personal conveyance in that situation. Just doesn't exist. It's a myth. The only situation something like that works under the guidance is if they run out of hours while they are at a shipper's or receiver's facility, and the shipper or receiver says you can't park here overnight. Then, and only then, does the personal conveyance guidance say that they can get to the next safe resting place. If they just didn't plan well enough and they run out of hours on the road and they switch themselves to personal conveyance, that is low-hanging fruit. That is a violation that's going to get written up every time. And those log falsification violations across the fleet add up very quickly, and it doesn't take many of them to end up with a conditional rating in an audit, if not an unsatisfactory rating. So keep that in mind. Log falsification, systemic issue across the industry that we really need to get a hold of because it's causing so many problems, not only in these contexts, but also in highway accident litigation. I mean, just look at, if you all are familiar with American Transportation Research Institute, ATRI. If you're not familiar with them, you should look them up, and you should look at some of the great studies and the reports that they put out. One of which was recently a closer look at these nuclear verdicts that our industry is struggling with and what's leading to them. And one of the incredible charts in that study, they updated this in 2025, was a look at the most common issues that end up with jury verdicts in excess of $10 million. So what types of negligence in the case are most likely to end up with a jury verdict in excess of $10 million? Number one on that list were hours of service violations. 75% of every case involving an hours of service violations ended up with a verdict in excess of $10 million. Just incredible. So log falsification plays a big role in that, obviously. Working our way down the list here. The next one is the failing to conduct an annual query through the clearinghouse. The next one is failing to register in the clearinghouse altogether. And then we get into some more hours of service, not using the appropriate method. This is another one that boggles my mind because more often than not using the appropriate method to record hours of service means that a driver is not using an ELD, even though we've had an ELD mandate now for over 5 years as well. So yeah, still a huge issue. And then somehow some maintenance one. Oh yeah, this is compliance reviews. So maintenance issues creep up there into the top 10. Okay, we can move on to the next slide. I should be looking at,
in the chat.
Yeah, I was going to say, we should be looking
Brandon.
at those. Yeah, go for it.
Yeah. So we conducted annual queries on all drivers. Many of our drivers were employed here prior to the clearinghouse existing. While we conduct annual queries, some members of our team are not registered in the clearinghouse. Do they all have to be enrolled? Is the question.
Yeah, I should have been more careful with my terminology there. You're correct that if they have been around with you since before the implementation of the clearinghouse in 2020, your only obligation is to run your annual queries on them. It's only when you get new employees that come to you after the implementation of the clearinghouse that you would have to do the pre-employment full queries. And so it wasn't as precise as it should have been when I said that this could come up roadside and they could see that your driver's not enrolled. What I should have said is it could come up roadside when an officer pulls over a CDL driver and they see that the company that they're driving for, the USDOT number, is not enrolled. I should have been more precise. Thanks for calling me on that. Anything else?
That's all we have so far.
All right, let's keep going. All right, so that's kind of a look back at 2025. The elephants in the room, because there are multiple of them, are the things that happened towards the end of 2025 that are bleeding over into 2026 and that are making the headlines in the news. And so I want to spend some time talking about them. addressing what they are, what they aren't, some of the, dispelling some of the misnomers about them. And those are English language proficiency and non-domiciled CDLs. What's the current status of these two enforcement initiatives? How did we get here? Where are we at currently? So that's what we're going to talk about. Again, if you got questions, throw them in the chat. We'll address them as we go. So starting then with English language proficiency. Many of you probably know that English language proficiency has long been a requirement that's been baked into the federal safety regulations. In fact, going back to the 1930s, we have had some rule on the books that requires regulated drivers to be able to read and speak English sufficiently to be able to read road signs and converse with law enforcement and fill out forms and that type of stuff. So that's not what's new. What is new within the last year is how closely the DOT examines this, or how aggressively it enforces it, I should say. That is something that tends to change, unfortunately, with what political party happens to be in office at any given moment. It is wrapped up in the politics, unfortunately. And so we often see the pendulum swing back and forth in terms of how aggressively it's enforced based on what political party happens to be in office. And we see that very clearly here within the last year. For the last 10 years, before President Trump took office for his second term, this requirement was in the regulations, but it was not enforced all that stringently. It was not an out-of-service violation, meaning that if your driver was not proficient in English and gets pulled over for a roadside inspection for the last 10 years, more likely than not that they would just be written up for the violation, but allowed to continue to operate. It was non-out of service. That all changed in June of 2025, as you probably will recall, shortly after President Trump signed an executive order that, among other things, required the DOT and the FMCSA to restore the out-of-service nature of these English language proficiency violations. And I say restore because this is what a lot of the national media forgets or doesn't even look into. This used to be an out-of-service violation in the past, and it was that way under the Obama administration, believe it or not, before it was taken out of the out-of-service criteria, like I said, about 10 years ago. So again, it's the pendulum swinging back and forth. But regardless, where we're at currently, here's the enforcement history. You can look at the timeline here. So in 2005, the Commercial Vehicle Safety Alliance added it to the out-of-service criteria. Then it lived that way for 10 years until 2015, when FMCSA relaxed enforcement and CVSA removed it from the out-of-service criteria. Then 10 years later, we end up with what we had effective last June, which is it's restored to its out-of-service status. And then even more so, why I think this issue is going to persist even past this current administration. This issue has now been codified into federal statutes, not just the federal safety regulations. You may have missed this, but in the last spending bill that kept the government at least partially open here within the last several weeks, in that spending bill was a codification of the out-of-service nature of the English language proficiency requirement, meaning there's a statement in that legislation that directs the FMCSA to put this in the out-of-service criteria by regulation. That's something new that has not happened ever before with respect to this type of violation specifically. So going forward, the Trump administration has made this harder. I shouldn't say the Trump administration. Republican legislators have made this harder for future administrations to relax because now it's going to be in federal statutes in addition to federal safety regulations. All right, next slide. All right, so how does this work in practice? Well, if you've experienced this roadside with any of your drivers, you're probably familiar with how it works, but under the new FMCSA enforcement policy and the CVSA's guidance on the topic, it's a two-part analysis. If your driver gets stopped for a roadside inspection and the officer picks up on the fact that the driver may be struggling with English, they are to kick off this two-step English language proficiency assessment. The first step is a driver interview, where the officer has to ask a series of questions and ask them in English and tell the driver to respond to them in English. And these are questions, they're laid out in the enforcement policy, which was originally redacted, so we didn't know what they are, but now we have an unredacted version, so we know what a lot of the questions are. But it's basic things that the officer would normally be asking anyway, like where are you coming from? What are you hauling in the trailer? Where are your logs? That type of stuff, those types of questions. But the driver is instructed to respond in English without the assistance of any kind of interpretive device or anything like that. And the officer listens for proficiency in English. And if the driver is not proficient to that officer's discretion, then they fail the ELP assessment and they're placed out of service for that violation. They don't move on to step 2 if they fail step 1. At least they're not supposed to. If they pass step 1, then the officer is directed under the policy to move on to step 2, which is a traffic sign recognition assessment, where the officer shows the driver a series of road signs. There's a list of them that they choose from. It's in that enforcement policy. And the driver is instructed to explain the meaning of the sign in English to the officer. And again, if the officer determines that the driver could not proficiently do that in English, then they fail them and then driver's placed out of service. If they pass the second step, that's the end of the assessment. They do not get the ELP violation. So drivers who fail either step are cited and placed out of service. Drivers who pass the assessment are allowed to continue operating. That's how it works. Next slide. So what's the data telling us about these English language proficiency violations? How big of a problem is this for the industry? What are we seeing nationwide? One of the things we do at Trucksafe is we're tracking the ELP data on a daily basis. This is a free tool that we make available to anybody that wants to see it. Trucksafe.com/ELP is where you'll find it. But it updates daily and it looks at all of the ELP violations written up roadside and what we're seeing month over month and state by state and that type of stuff. So what we're looking at here is kind of a line graph looking at the uptick in ELP violations, out of service related violations starting in June of 2025. That's when the out of service criteria was updated. So you could see it starting to rise then. And then we've seen a pretty steady increase all of last year, and now it's starting to level off at about 2,000. Well, you could see there the average per month. 1,035 over the last 9 months has been the average from month to month of ELP out of service violations being written up roadside, with a peak month of January of this year with 2,113 ELP violations being written up. So how many total English language proficiency out of service violations have the various states written since the new enforcement policy, go back one slide, sorry. Since the new enforcement policy went into effect in June of 2025, that's the top number there, 14,491 total ELP violations written up since June. All right, next slide. This is a kind of a state by state look. What are the top states writing up English language proficiency violations over the last several months since June? Well, probably no surprises here. Texas is at the top of the list with the most out of service ELP violations, a little over 1,800 of those written up since June. Then working the way down that list there, Arkansas, Wyoming, Florida, Arizona, Tennessee, California, surprisingly. You may have been, if you've been following the news, you may know that California got its wrist slapped by FMCSA a couple of months ago for not enforcing ELP at all. So for the first several months of enhanced enforcement of ELP, California literally had one out of service ELP violation written up. I don't know who that one guy was, but he was unlucky for about 6 months there, probably about 4 or 5 months. California had only one out of service violation ELP written up. Now it has gotten its act together, probably because the FMCSA threatened to withhold so much federal funding from it, that it is now in the list of top 10 states. It's at number 7. So those are just looking at the states and what their enforcement looks like. Again, that's something you can find on that ELP resource I mentioned that we're doing, trucksafe.com/ELP. You could put in your own state and see and see kind of a look at how aggressively your state's enforcing it. Next slide.
We got a couple questions coming in, Brandon, all very similar. How does a driver that gets put out of service for ELP violations get back to running?
This is the $1 million question that nobody that I could tell has an answer for, unfortunately. There is no guidance from FMCSA. There is no guidance from CVSA on this topic. My driver gets placed out of service for English language proficiency. How do I get them back in service? The trick or the issue with this is that English language proficiency is such a subjective issue, right? Normally, if you have any other kind of out of service violation, if your tire's flat, for example, well, how do you get back in service? You fix the tire. The nuance or the distinction then with English language proficiency is because it's so subjective, what one officer thinks was proficient, the next officer down the road may think is not proficient. How, if I'm that driver that got placed out of service by the first officer, how do I prove my proficiency sufficiently so that I can put myself back in service so that I don't run into this issue in the future? Well, I mean, the best I can do is give you some tips, some things I think you should have. It's not bulletproof because the agency hasn't addressed it. But I think at the very least, if you have a driver that's placed out of service for ELP, I think they got to go through some kind of training on English language training. And I think it needs to be substantive training. I've heard of too many fleets end up in this situation and they end up putting their driver in like a 30-minute course or an hour course. You're not going to, if you're not proficient in English, you're not going to learn to be proficient in English in 30 minutes or an hour. I mean, I took like 4 years of Spanish in high school and college, and I still can't speak any of it. So 30 minutes in an hour is not going to cut it. I think they need to be enrolled in some kind of a substantive English language training, and then you need to have some kind of proof of that training that they've successfully passed it, like a certificate or something, and then have that at your disposal. Then with that type of proof, I think you've got a good faith argument to make that to put them back in the truck at that point. You probably want to do another assessment of your own before you do that. If this is your driver and they've gone through that training, you've got that certificate, now you just do your own assessment. Do you feel comfortable that they are now proficient? And if so, put them back in the truck. And then if they run into the issue again, another officer puts them out of service, then at least you've got that evidence available to you to file a data queues challenge on the back end, for example. Is that it for the questions?
Yeah, there was a second part, and I think you just answered it, but is there any success to get one of these type of violations data queued and removed?
That's a good question. I haven't filed any of these personally, so I don't know what the success rate is for those that have. So if anybody else in the chat has tried it, weigh in. Let us know if you had any success or not. Okay, so to wrap up English language proficiency here, my recommendations are these. Carriers should, at bare minimum, be assessing English language proficiency during the driver onboarding process through some kind of a documented process. Even if it could be as simple as you just talking with the driver through the application process yourself and documenting their proficiency, but you need to have some documentation that you've done something. We're starting to see an emergence of some other cool technologies. We're partnered with one called ELP Ready. That's pretty cool. It's an AI assessment tool that, you send the driver a link and they talk to an AI agent on the phone and it assesses their proficiency and it shows them signs and stuff like that. I'm not saying you have to do anything like that, technologically speaking, but you got to do something is my recommendation. Also, we already hit on this one, so I won't dwell on it, but you need to take care to document your rehabilitation for any drivers that you plan to put back in service after they've been sidelined for English language proficiency, not just from a DOT perspective. I'm not just worried about your exposure to DOT enforcement for putting these drivers back on the road after they've been found deficient. I'm more worried about the highway accident exposure that creates. Obviously, again, just turn on the news. These are flooding the national news with stories of drivers who are not proficient in English causing substantial accidents. And even though they're probably a small subset of the total accidents across the nation, The fact of the matter is they're getting big media attention, and that's placing a big and growing target on your back. And that's not going to play out well in litigation for those carriers that end up in that situation. So tread cautiously in this area is my recommendation. All right, let's move on.
Brandon, a question that got buried in the chat before we get to the next topic was related to ELD mandate. Does it also include those who are local?
Yeah, so the ELD mandate, remember, has a few carve-outs for folks that still get out of having to use ELDs, one of which are short-haul drivers. So drivers who fall within the short-haul exemption, 150 air miles of their normal work reporting location, working no more than 14 hours per day, they qualify for that exemption, and they can keep time cards. They don't have to have driver logs, and they don't have to have ELDs. And so, yeah, maybe not so much of an issue for them, but I'll caution you there, because we see this all the time. Just make sure you're keeping time cards, number one, for those drivers, and making sure that you have controls in place so that if they exceed the scope of that short haul exemption, either by the air mile radius or by those 14-hour working hour limits, that you then require them to transition to a driver log or ELD in that situation. Too often, fleets just assume they're short haul and then they don't do anything else. And then all of a sudden they've got drivers who, one day out of the week need to go beyond 150 air miles. They're supposed to have a log that day. And if they do that more than 8 times in a 30-day period, they're supposed to have an ELD. So my caution to you is, if you're a short haul fleet, just make sure you got those controls in place to address situations where your drivers might possibly exceed the scope of that exemption. All right, moving on then to non-domiciled CDLs. The other thing that ended up on national news last year and continues to be a prominent issue in the news cycles into 2026. What are non-domiciled CDLs? First of all, I found so many folks, especially those in the media, just don't even know what these are. And, that's not all that surprising, because until recently, you may not have even known that such a thing even exists. So what is a non-domiciled CDL? Well, these are a variety of commercial driver's licenses that are, number one, governed by regulation. There have been existing guardrails put up in the regulations about who's entitled to receive these licenses, and I've listed the regulation there, 383.23. But these are licenses, special types of commercial driver's licenses that are issued. The regulations allow them to be issued in 2 specific instances. The first one you hardly ever see. In fact, I don't think you ever see this. But one instance where a non-domiciled CDL would be appropriate is being issued to an individual who is a resident of a U.S. state that happens to not be authorized to issue CDLs. Right now, all of the states in the country are authorized by FMCSA to issue CDLs. So we haven't had this issue. But theoretically, if ever there was a state whose authority to issue CDLs was yanked by FMCSA, and I laugh because this is a real possibility, because if you've been following the news, the FMCSA has threatened to yank California's ability to even issue CDLs. And if that were to happen, the ironic thing about that is that, I can't remember how many total, I think it's upwards of like 700,000 CDL drivers live and are residents of California. If the FMCSA were to yank California's ability to issue CDLs, and all of a sudden California can't issue CDLs to those 700,000 drivers, the ironic thing is that if those drivers wanted to continue operating in the United States, they would have to go to a neighboring state and get a non-domiciled CDL to continue doing it. That's one of the authorized instances of a non-domiciled CDL. The other one is the more common one, and the one that we're dealing with in the news nowadays. And this is non-domiciled CDLs are issued to foreign nationals who meet certain criteria. Foreign nationals who are here in the U.S. operating these larger trucks or buses. They can't get a state-issued CDL because they're not residents of any state. So the only way that they can operate a CDL-sized vehicle is with a non-domiciled CDL. One caveat here that I should mention is that, and this is one of the issues we're seeing with this rule, or why the FMCSA is cracking down on it. We're talking about foreign nationals from countries other than Mexico or Canada when we're talking about non-domiciled CDLs. Mexico and Canadian drivers, we have trade agreements with those two countries, NAFTA, that allows those drivers to operate in the U.S. using their own Canadian CDL or Mexican CDL. So they don't need non-domiciled CDLs. They operate under their national CDLs. And so those drivers, if they are residents of those countries, are not eligible for non-domiciled CDLs under the current regulation. But one of the big problems was, as the FMCSA started auditing these CDLs issued by various states, they found that many states were issuing them to Mexico or Canadian domiciled drivers improperly. They don't need them because they're supposed to be operating on their own country's CDLs in the U.S. So that's one issue. But anyway, point is here, foreign nationals who meet certain criteria are historically eligible for non-domiciled CDLs. Problem is, here's the historic eligibility. You could see historically, if you were a foreign national and you had a non-expired employment authorization document or an I-94 form and foreign passport, you could apply for a non-domiciled CDL. You still had to pass the same knowledge and skills test that a U.S. resident would. Your non-domiciled CDL is supposed to be marked prominently as non-domiciled on the front of it. And motor carriers still have to do clearinghouse checks. Those were the guardrails that have been up for many years. We can go to the next slide. Problem is, as the FMCSA started digging into this, after very high-profile crashes, they quickly learned that there was a big problem when it came to states issuing these types of licenses. Here was just a statement from Duffy. I'm not going to read it. You probably heard him note this in his many press conferences, but I think his infamous words were, "Our CDL system is broken," was his conclusion after looking at the audit findings. We can go to the next slide.
Hey, Brandon, how do you verify valid CDL for a Mexican or Canadian driver?
Yeah, so the regulations were changed on that a few years back. They say you're supposed to run an MVR through the Canadian authority that issues those licenses or the Mexican authority. The regulations, I think, set out the link where you can go run those MVRs, but you are, as a motor carrier employing those drivers, you're supposed to be running an MVR through those national licensing agencies that issued those licenses to those drivers. There's a specific websites where you can do that. All right. So what were some of the audit findings? As FMCSA is digging into non-domiciled CDLs, what were the problems they found? They found systemic non-compliance across several states. The worst and most egregious was California. The slide's a little bit outdated now. I mean, I put it together a couple weeks ago, but since then, we've seen FMCSA issue letters of non-compliance to several other states, including New York and Illinois and Minnesota. Several of these states are getting these letters of non-compliance. You could see 24 states, in fact. And it's not all blue states. I mean, it looks like that when you just turn on the news, but there are some red states that have gotten these letters as well, alerting them to areas of where they have issued non-domiciled CDLs improperly. Some of these numbers are depressing. If you look at California and New York in particular, New York, according to the FMCSA's audit, over half of the non-domiciled CDLs issued by the state of New York were issued improperly, meaning that the driver didn't meet the criteria that's set out in the regulations. Just crazy numbers. And so FMCSA is sending out these letters to these states and directing them to get the issue under control. Number one, stop issuing these types of non-domiciled CDLs until you ensure that you have the proper controls in place, and also audit all of the existing ones that you've already issued and figure out whether they were issued improperly or not, and if so, do something about it. That's the directive to the states. Overall findings of weak oversight, insufficient training, and programming years. All right, next slide. So that leads us to where we're at currently. We've already talked about the California repercussions for this, but this led the agency to, they were so concerned with what they found in their audit that they issued what was called an interim final rule. It's like an emergency rulemaking. You probably remember this from last October. It was an emergency rule, and so it went into effect immediately rather than the normal notice and comment period that we expect with federal regulations. It went into effect immediately and made some pretty sweeping changes to who's eligible to get these non-domiciled CDLs. You may have heard that whole issue got caught up in litigation. We ended up with a federal court, DC Circuit Court of Appeals, staying the rule, meaning not allowing it to go live. And that was the case. We had a stayed rule for several months until FMCSA earlier this month, February 13th, issued a final rule. So now going through the actual rulemaking process where they solicited comments. I think they got over 8,000 comments to the docket on this rule. They supposedly considered those comments, and they came out with the final rule, February 13th, 2026, which is now set to be effective March 16th, I believe, of 2026. And so what does the final rule say? It says basically the same thing as that emergency rule that got stayed by the court. So we can go to the next slide. Here's who's eligible under the new final rule for non-domiciled CDLs. It's certain categories of visa holders, namely H-2A agricultural workers, H-2B non-agricultural workers, E-2 treaty investors, and that's it. No more asylum seekers or DACA recipients, which were a big population of the existing non-domiciled CDL holders. Just those three categories of foreign nationals are eligible for non-domiciled CDLs going forward. Another big change from where we were at historically, no more employment authorization documents, only an I-94 and unexpired foreign passport in order for a driver to be eligible to get a non-domiciled CDL. And the big one here, no more lengthy terms on non-domiciled CDLs. I think the average term for a non-domiciled CDL currently, according to the FMCSA's data, is 5 years, meaning states were issuing these for 5 years. They're valid for 5 years, even though the driver's work authorization, their authorization to be in the country to work, expired well before that. Why were we issuing these long-term non-domiciled CDLs to folks who weren't going to be authorized to work here anymore for several years during the validity date of that license? Didn't make any sense, obviously. So now the FMCSA is making clear in the final rule that these non-domiciled CDLs are only valid for the length of the work authorization or 1 year, whichever is sooner. So in no case will you have a non-domiciled CDL holder whose license is valid for more than a year going forward. There's a lot more we could talk about there, but we're about out of time, so let's keep moving here. We'll finish with recommendations for non-domiciled CDLs, and then I'll just hit on some honorable mentions here. I have a lot of fleets asking me what they should do about non-domiciled CDLs. My biggest piece of advice to you, if nothing else, is that you take stock of your current fleet of drivers and at least get some visibility as to which of your current drivers have non-domiciled CDLs. I think that's the biggest thing you could do right now, because we're still in a bit of a wait and see pattern, because I'm worried. Well, we've already seen this. There's been a group that's already filed a federal lawsuit to challenge the FMCSA's authority to issue the final rule. And so could we end up with another stay of the final rule? We could very well end up there. But we're going to proceed for now as if the rule is going to take effect on March 16th. So you need to take stock of what drivers in your existing fleet of drivers is going to be potentially impacted by this final rule. Does this mean all of a sudden on March 16th, all 200,000 non-domiciled CDL holders in the country are going to lose their license? No, the FMCSA said explicitly that's not what it means. They're going to let those non-domiciled CDLs lapse or go according to their terms. So we're going to see probably a general phase out of that population of around 200,000 drivers over the next 5 years is what the FMCSA is expecting. So taking stock of what you got now in terms of non-domiciled CDLs in your fleet is important. And then also the most important thing I think you could do, this is not required by the regulations, but it's something that I recommend to all of my fleet clients, is that you enroll your fleet in some kind of a continuous license monitoring software. There are many providers of that type of service now. It lets you know pretty immediately anytime a driver loses their license or it's downgraded or something to that effect. Putting aside the non-domiciled CDL issue, that's a valuable resource to you for many reasons, but it is particularly useful to fleets that have non-domiciled CDL holders, because then at least if they're out there driving and all of a sudden one of their states yanks their non-domiciled CDL, you should quickly get an alert through that alerting system, and then you could take action to get them off the road, because you don't want to have a driver out there on the road operating on an invalid CDL, obviously. All right, next slide. Miscellaneous. These are the honorable mentions. I've got like 2 minutes to talk about these, so we're not going to get much accomplished in that. Just know that these things are, percolating up, and they're going to continue to be issues in 2026. One is FMCSA cracking down on electronic logging device providers. They're investigating a lot of these providers and finding, not surprisingly, that a lot of the self-certified devices are not actually compliant with the technical specifications, and then they're yanking them from the market. They're yanking them from the self-certification list. So when it comes to ELDs, usually my advice to fleets is go with a trusted, well-known brand of ELD, so that you don't end up with devices on trucks that get yanked from the list and now you got to replace them. Kind of same thing with entry-level driver training providers. FMCSA is also cracking down on the universe of like 34,000 training providers that now exist in the system that are also self-certified that they meet the requirements. Turns out a lot of them don't, and so we have drivers progressing through these training programs that may not even have a curriculum, and they may take like a day to get done or something just crazy. And then the drivers end up getting a CDL and they're not properly trained. So FMCSA is cracking down, removing many of these training providers from the list, and that's going to continue to be a thing this year. I'll leave it at that, and I'll turn it back over to Chris. Sorry we ran out of time there all. But yeah, thanks everybody for sticking around. And if you got any questions for me on any of these topics, or need any other resources for this type of information, feel free to follow us on any of our platforms that we've got listed here, or reach out to me directly with questions.
Brandon's contact information's listed here. We will also make sure to get this information out to all of our participants as soon as possible. So if you do have any additional questions we weren't able to get to, again, here's Brandon's contact info. I just want to give a huge thank you to Brandon for sharing his knowledge and expertise, and for your participation. We look forward to seeing you at the next session. Have a great rest of your day.